A major constitutional storm is brewing in Nigeria's corporate regulatory space as senior lawyers and civil society groups escalate a legal battle over key provisions of the Companies and Allied Matters Act, Cama 2020. The Corporate Affairs Commission is now at the center of renewed legal fire, with critics warning that its powers may be stretching beyond constitutional boundaries. Leading advocacy groups, including Global Rights and Nulai Nigeria, argue that recent interpretations of Cama are granting the Commission sweeping authority, erasing the clear separation between administrative oversight and judicial functions. At the heart of the dispute are concerns that such powers could erode constitutional guarantees, particularly the fight to a fair hearing and due process. At the Stakeholders Roundtable in Abuja, legal scholar Sam Erugo San disclosed that a federal high court ruling in October 2025 has cleared the matter for appeal.
Amend certain provisions of the Companies and Allied Matters Act that appears to contravene certain constitutional provisions, particularly with regards to right to freedom of association, which is very critical, with right to fair hearing, and of course, right to civic participation. So when you look at certain provisions of the amended Companies and Allied Matters, you find out that there are some of those provisions that appear to infringe on these rights. If you take, for instance, Section 824, it attempts to determine classification of registration. We are talking about civil registration. Of course, associations outside those doing business in Nigeria are now regulated by the Companies and Allied Matters Act. If you want to register any organization today, be it a church, be it NGO, civil society organizations, you find out that you are right.
Erugo warned that parts of the law may conflict with the Constitution, calling for enhancement to strengthen transparency and public participation. Technical consultant Innocent Lagi and civil society advocate Noya CD insists that adjudicative powers must remain strictly within the judiciary to preserve institutional checks and balances.
It is important that we understand we do not challenge the duty of government to regulate, but it has to be done in accordance to the law. That laws have to be made to streamline with the Constitution. Laws that are made to infringe the Constitution or diminish impacts of provisions of the Constitution are challengeable, and we believe we can further challenge that and continue to challenge that as long as it creates a scenario for the rule of law and governance in accordance to the Constitution. Cama. It simply means the National Assembly had carried away the duties and powers of courts and given them to Cama, thereby eroding the right to fair hearing of persons in the determination of their civil rights and obligations. So the whole idea is we are not saying that people cannot infringe on provisions of Cama, but that the CAC cannot be a judge in its own cause. You can't have the CAC be the accuser, the judge.
While stakeholders acknowledge the need for effective regulation, they insist it must remain firmly within constitutional limits. As the case advances to the appellate courts, its outcomes could reshape not only Nigeria's corporate regulatory framework, but also the balance between state authority and constitutional governance.